Thank you, everybody. I hope you can hear me. So first of all, I'd like to say that following the stage of after Ryan is kind of an honor to me, because I cannot even count the times I have been called in courtrooms that Fanboy doesn't even exist, or that EasyList is a scheme of eyeo. So actually now we have the video proof that we were not lying at court when I said this guy really exists. So anyway, thank you, Ben, for introducing myself. My name is Recke. I'm the general counsel of the eyeo group. And first of all, I'm sorry that I can't make it to Amsterdam. I'm on my family holiday these days in the lovely Black Forest, southern part of Germany, but I didn't want to lose the opportunity to speak to you anyway about a very recent lawsuit that we again won, which has not been published anywhere as far as I can see, in the international magazines at least. So you get it exclusive in this summit. And the case, no spoiler here, the case is Axel Springer against eyeo, part, I lost track, let's say 5 or 6. But before we get to that, I like to start with a little bit of history, because not everybody is aware of where we're coming from, and not everybody is aware of all the lawsuits that we fought. And it's like, it's ad blocking or ad filtering. What could somebody have against it? Spoiler, what if you would have to live in a world where GET request blocking or CSS prioritization would be illegal? Will that impact your products or your browsing behavior? Let's see if I can give you the answer at the end of the presentation. Wait. But before we get to that, another question. What is the best way for publishers to get rid of ad filtering? Well, obviously, in this room, everybody knows the answer. Stop making annoying ads, right? So respect your client, which is the user. And to be fair, for many publishers out there, that is actually the right answer, and they follow that path. But some do not, and some look into other things, and they try, as part of their strategy against ad filtering, to sue users, to sue ad filtering developers. And that what happened in the last 10 years. So in the last 10 years, we battled about 15 lawsuits in parallel. We spent a ridiculous amount of resources into it. And let me think about what we do along the way, just to give you a little bit highlights, because otherwise we're talking here for hours. Well, we successfully, prevented them to be successful. So we won all of these lawsuits. We rejected accusations in the United States. We rejected accusations in the UK. Oh, by the way, we got our offices raided and our private living rooms for false accusations of certain publishers in Germany. And last but not least, we protected EasyList, some days and several occasions, and its authors. So now, after all of that, can't we just agree that it's over? That suing ad filtering users is not the right answer to the question, what could you do against ad filtering users on your websites? Not really. Well, I thought so. I thought it is over. After we won in 2018, the Supreme Court decision in Germany, where basic questions of fairness have been handled, let's put it like that. Legal aspects of it, there is an act called Unfair Competition Act, which is European harmonized. So it basically just says, if you compete with somebody, do it in a fair way. And Axel Springer and other publishers base their accusations against ad filtering users on that principle, saying that users who use an ad filtering software use it in an unfair way, or better said, the developers of this software must not distribute it so that user can use it, because it would obstruct competition. In a nutshell, as a publisher, you don't make enough money, because ad filtering exists, and that's unfair. So I skip all the instances. We just directly go to the Supreme Court, 2018. The Supreme Court looked at it and said, we have to balance all the interests of everybody against each other to consider it fair or unfair. And they said, well, we have constitutional rights on both sides. for the publisher, freedom of press, freedom of business. For eyeo, freedom of business. For the users, well, the right not to look at information if they don't want to, and information not being ads. And at the end of the day, they said the tipping point for us is that publishers are not defenseless, that they can lock out users. All the anti-ad block laws that you see all over the web, actually, they are the reason why ad blocking is still legal in the European Union. So that was 2018. And the plaintiff back then, Axel Springer, they went on to the Constitutional Court in Germany and said this Supreme Court decision is against the German Constitution, so you have to overturn this decision. And the Constitutional Court in Germany said, no, we don't think so. It's a good judgment. So, end of story, right? But not with Axel Springer. They looked in and said, let's get creative. There is this directive 2009, I put it here on the slide, which basically grants protection to computer programs, the source code of it. Now, under copyright, again, a European harmonized act, and very similar in the States, by the way. You have to understand that you can do whatever you like with copyright protected material in your private living room, right? You can buy the Mona Lisa and overpaint it. You can buy a really famous poem and rewrite it. Nobody cares. It's not an infringement of copyright. As long as you're not further distribute it, publish this, or do some other things in public about it. But not with computer program code. Why? Because the European Union wanted to protect updates. They wanted to have computer code softwares like Microsoft being able to sell updates. So if you have the skills to rewrite source code of proprietary software, it is a computer copyright infringement to do so. Even if you could do it in your private living room, nobody would notice.
Guy, excuse me for a minute.
Yes.
Can you share your screen? Because I think you have some slides, but we don't see them.
Oh, sure. I was thinking that we have slides here. Wait a second. Thank you for telling me.
No worries.
I know, I talked about all this stuff and you missed all the cat pictures. Okay, let's try this again.
Thanks so much.
So, welcome to the court's history. Let's see. I thought it's over. Basically, that picture, by the way, is from the most well-known German news stations back then. It was kind of more cool to me to have it in the Tagesschau than actually been at court, to be honest. And that is the slide that we were just at when you pointed out that I'm not sharing the screen. So this directive is basically protecting computer program code from being changed. Now, directives have to be transported into national law, and in Germany we did that with this section 69C. Now, sorry, it's getting a little bit legalized here, but bear with me. I try to explain it in a way that even people who hate legal stuff find it maybe interesting. So what that law says is, like, anytime you deal with a computer program, you have to ask for permission. You have to ask the person who wrote the program if it's cool for him, if you change the code, if you modify the code, or do some, publish the code, of course. So then Axel Springer said, okay, what if, and they said this is a quote from the judgment that we just won, from the part where the judgment cited the plaintiff. And Axel Springer, the plaintiff here, says, like, you know what, HTML, or the websites written in HTML, are computer program code. Maybe not in the old days where we said like markup language, whatever, but these days there is so much interactivity that at least the Axel Springer websites have to be considered computer programs. And the same actually is true for the DOM and the CSS, because they are just interpretations of the computer program code, and as such, which is true, by law are protected as well. Now, when I first heard that argumentation, I think I agree, or I was agreed by a lot of my colleagues, we basically thought that is interesting because that has never been thought about. Why? Because who cares? Nobody cares if you're dealing in your private living room with computer program code normally. But here we have a direct financial impact. So I understand that it's being at least done. And they went to Hamburg, to the court of Hamburg, which is known to be very IP friendly. So it makes sense that they choose this court to hear this case. And the first question, as I just mentioned, is like, is HTML or a website written in HTML actually legally a computer program? Now, there is no real legal definition, right? So it's not in the law that says, like in any act that says, if this and this exists, then it's a computer program. We have some WIPO definitions that are referenced some here, but in a nutshell, it just said, if there are instructions that are instructing some information technology to do something, I cannot put it more general like that, then we have a computer program. It's very general, very broad. So what did the first and second instance in Hamburg decide about that topic? They said, oh, we don't know. We don't know. It could be, we don't want to rule it out. It's rather unlikely, but, luckily for us, we don't have to decide. We leave that to the big boys. We leave that to the European high courts and the Supreme Courts. We don't have to decide it because there's another thing that we have to decide about. And this is actually the core of this lawsuit. The question, can I prevent certain browser configurations or browser technology from being used by any kind of internet user without permission by an HTML writer, developer, whatever you want to call it? And in that particular case, it was about GET request blocking, so that a browser is not executing URL requests. And the question of element hiding, you all know, kind of CSS prioritization, where you just put an important exclamation mark, CSS information, and then browser technology, W3C standards are actually cascading it into a way that user agents or user information are always prioritized. And Axel Springer challenged that, and they said, no, that's not the right way to do it. It should be always developer first. And the Higher Regional Court in Hamburg looked at it and they said, no, I don't think so. But they said that after we exchanged about 500 pages of experts' opinion, and we battled for about 3 years. So it was a very, very technical case. And the problem with technical cases is that judges are no technical persons. So the argumentation of Axel Springer went into a scenario where they said, you have to prevent that because it's ad filtering. And they did not show to the court like the bigger implication that this success would have. Because what it actually means, and the court did see that because we said it over and over again, that what the plaintiffs brought to the court is basically an accusation that the DOM tree and the CSS song, some other parts, are not being rendered or created as the plaintiff intended it, but that the plaintiff has no right to a certain DOM tree or CSS. And especially in the blocking of, or element hiding blocking technology, they said maybe they're changing something, but they only change parts that are not HTML. So we can leave the question open if HTML is a computer program because they are not changing HTML. So even if it would be a computer program, everything that ad filtering extensions do, everything that browsers do, because it's not limited to ad filtering extensions, it's basically every technology that does that. They're not messing with HTML, at least in this case. And then they repeated something that was one of the core aspects of this case, in my opinion. At least that was the reason that I introduced it to the court. It was that we said, dear Mr. Judge, look at it. If you grant this protection, you grant protection against anti-tracking tools, deactivating JavaScript, block pop-ups, or it wasn't quoted in this judgment here, but I like this example very much, even software that prohibits spoilers of Game of Thrones. Back then, very popular. You see how long these lawsuits take. So they see that, the judges saw that, and they said, okay, then we have to dismiss this case. And as you can see on the first slide, and go back very quickly, As you can see, it's from August 24th, so 2 weeks ago, roughly. Now, end of story. Did we won? Again, is now finally this question over of, is ad filtering safe for users to do, safe for developers to do? Can we finally just shape the browser industries and do the best for the users without having the sword above our head that one day one of these publishers will successfully sue us and then drain the distribution channels? Well, not really. Sorry to disappoint you. But this case is, as I said, very, very technical and complex. And one of the aspects of this case is whether or not, if it would be a computer program, it would be sufficient if, even if HTML, a computer program, is not being changed, the execution of that computer program might be changed. And now the Supreme Court, in a different decision, in the case Action Replay against Sony or Sony against Action Replay, just decided this question is so important to European copyright that they will ask the European High Court to decide about it. So the question of if a source code is not changed, but in that particular case, you insert a cheat software who changes some variables in the cache, and then the result of the execution of the computer program is not as expected by the computer program author, is different. Is that maybe the same as changing the source code? Now, the Higher Regional Court in Hamburg already said that they have high doubts that our case is similar to that case, but nevertheless, it could be, and they leave it up to the Supreme Court, and that's why they allowed the next step for Axel Springer to be the Supreme Court. So we already received the papers. They filed the challenge this decision already. So I expect the Supreme Court decision early next year, maybe mid of next year. Obviously, I'm quite positive about the outcome from our perspective. And hopefully then it's over, but I'm not sure if not, again, the European High Court will take a second look again. So to be continued at European High Court. Last slide on that, and then happy to take questions and answer questions. And sorry, no cat pictures, I lied to you. Until the European High Court renders a final decision, 3 bullet points that I like to have everybody in this room to remember. HTML modifications might be an issue under European copyright law. Highly unlikely, but watch the Supreme Court decision to be sure. Ad filter developers should be careful until then in using HTML altering techniques like HTML filter. Just be careful in the European Union. And last but not least, and this is really, really important, don't mess with anti-ad block walls if you are somehow active in the European Union. That is something that could really break your neck if somebody is looking at that and is trying to get your hands at court. And remember, they don't have to sue you in your hometown. They can sue you in any European country and then just file a complaint with the distribution channels. Thank you for your attention. Happy to take questions. And I think I can now stop sharing my screen.
Thank you, Kai. Who has the little catch box? And who's got a question? Oh, here we go.
Hi, Kai. First of all, I'm a big fan, and I'm very happy that we have you on our side, because if you were on their side, we would be doomed, probably. And the question that I have for you is, what do you think about the DMCA angle that was kind of explored a little bit by some US companies, but it kind of stopped and wasn't developed anymore? So what are your thoughts on how dangerous it could be?
Yeah, thank you for this question. I think that if I remember correctly, back then it was a complaint by was it Admiral against somebody?
Yeah.
I don't recall it correctly, but I saw something
Against Ryan.
Yeah, I think that DMCA complaints are a slippery road. I mean, on the one hand, you get a very quick decision sometimes, and you don't go to court about it. You file a complaint at the service provider, and that's why most of the DMCA's complaints are actually successful because very few service providers fight back in the names of their clients because it's a financially easier solution to just kick out the complaint issue or the complaint filter in that particular case. So that's why I think that DMCA complaints can be quite successful for publishers. This being said, also these kind of DMCA complaints most of the time lack merits. So if you have the resources to fight back about that and to defend them, most of the time you will be successful because copyright is a very complex issue. And just take anti-ad block walls. When I said be careful with it, the complexity is in the details. Some of them are to be protected, some might be not protected. And with DMCA complaints, most of them, if not all, are based by copyright. So yeah, you see how I try to find an answer to your question who fits into a nutshell, but there isn't any. It's really down to the particular case. You have to take it serious, but if you have a good lawyer on your side, you should be able to defend it.
Okay, I know one good lawyer. Thank you.
We're going cross room here. Not bad. Impressive.
Thanks. So hi, it's really fascinating how creative those lawyers from Axel Springer get. And I wonder if their line of thinking would be hold correct. Would this make the browser vendors that implement content filtering techniques co-liable of ad blocking?
Yes. Not ad filtering. Look at it from a bigger picture. Every technology that uses GET request blocking or CSS prioritization, any extension, any browser configuration option, it would all be subject to this case law. So that's this is the point that I like to get across, not only at court, but also in this room. This case is not about ad filtering. Ad filtering is an example of what this case is about. And browsers, developers should be very careful watching this case. I'm totally convinced that we will be positively end this case and that there will be no negative consequences. But, if the plaintiffs would be more into it and looking at, maybe different targets, who knows what would have happened.
So even the worst case scenario, in the meantime, could we think that, let's say, that the next ruling will be negative for the ad filtering, then the case won't be Axel Springer against eyeo, but Axel Springer against Google. So
Axel Springer against Google, Axel Springer against Opera. I would say Axel Springer against anyone who is not a partner of Axel Springer.
So we're on the safe side, I guess, with the budget war. Thank you.
Hi, thank you for the talk, very interesting. I'm going to ask a silly question about HTML because, so when they attack websites written in HTML, so do they just mean the kind of the underlying technology that the website can be translated in HTML? Because technically I can write from a website in Markdown or using those constructors.
Yeah.
So would that be...
The argument that the plaintiffs brought to court is, they started, I have to elaborate more on that, because they started very broad. They said, look, our website is not just the front end, how they called it. It's the front end, the HTML website, considering together with the back end, the server side. And the interaction between both of them is one big computer program. Now we torn this argumentation apart and we just said this is nonsense. So we just, at the end of the day, looked at what happens at the computer of the user, which is HTML execution or visualization at the browser level. And here Axel Springer, or the plaintiff, argumented that due to the many interactive elements within HTML code, so it's the writing of HTML websites, it's not software used to write HTML. That has not been targeted. It's the HTML website itself. Is so highly interactive due to JavaScripts being implemented, Flash, and, well, according to the plaintiff, even URLs embedded in HTML should have an instructive character, because then the browser is calling these URLs the GET requests. And that is an instruction to the software, the browser, to do something again and again. I'm saying this is the argumentation of the plaintiffs. It's not making sense, but if you make it too complex and overly complex, the strategy is to just find a judge who doesn't get it. But to answer your question, it's about HTML, not the software used to create HTML.
Okay, thank you.
Finding a judge who doesn't get it sounds like justice to me, or maybe the opposite of that. Wish we could go on, but you all have coffee to drink downstairs. So we're going to do a coffee break for 30 minutes. But before we do that, let's have a round of applause for Kai.
Have fun in Amsterdam. Hope to see you next time.